Good afternoon, everybody, and it's terrific to be here. My first January in 23 back with all of you. I'm hopeful that you had a terrific New Year holiday. Last time I was with you, we were in the midst of that terrible cold snap, and our hearts continue to go out to those in communities like Buffalo, where, of course, there was some loss around the storms that were so affecting. What we're here today to cover is the highlights of 2022. It was a full year. There was much that happened in the world of law and policy that we want to make sure we bring to you. This is going to be the first of what will be two look back programs, both this afternoon and then the following Tuesday will be devoted to 2022. And then as we move later into the month, programs 3 and 4 will be focused on what we can expect ahead in 2023 based on what we know. And we're going to be looking at these issues from the various practice areas and the perspectives that we as bond attorneys bring to the issues that we're going to be discussing today. And I'll kick things off in a moment, but if Kathy, you'd kindly go to the next slide, I'll walk you through our program for this afternoon as a group. So here's the agenda. After I'm done covering a few healthcare relating items, I'll move on and Dave Ferrara will be our next speaker. Dave has been on the program before and we'll be looking back at 2022 in employment law. Thereafter, John Godso will be with us from Buffalo. Dave, I should point out, is with us from Syracuse, and John will be covering employee benefits. Seth Gilbertson, also in the Buffalo office, is going to address higher education. And then Rick Weber will look closely at the Adult Survivors Act, which cuts across a few different domains. Rick will be with us from Syracuse, and then I'll close things out with a chance to answer your questions should you have them. But why don't we first go to the next slide, please, Kathy, and I can walk through what we've observed in the healthcare environment during what was a very full 2022. And as you see, and as each of you is living every day, you can appreciate that we're not out of the woods yet. With regard to the public health emergency with COVID and all of the challenges that have been part of what it has meant to all of you to operate your businesses and otherwise go about your days during this last year. Masking is still on the list. Though the requirements for masking generally have been eliminated throughout 2022, there's a lingering recommendation here in New York City, where I'm speaking with you from. I can tell you that it's just that, a recommendation, and people are sometimes masking, often not. As far as staffing is concerned, the emergency across the healthcare environment remains in place, and it's really dependent on the healthcare setting in terms of how that is ultimately manifesting, but generally there's a lot of stress around staffing still in the healthcare environment, no doubt. COVID sick leave policies remain as they were. It's possible the legislature will take another look at this over time, but until that happens, the leave policies do remain in place. Quarantine and isolation policies generally in New York State have come into some greater alignment with federal policies, and they're less restrictive than they were, and that was a big 2022 trend. Vaccination is another big topic to make sure we reference, simply in that the bivalent boosters are out there really for any population, whether kids or adults, that wants them. The uptake, however, has been variable depending on the community, and we'll be continuing to watch that as we move into 23. Next slide, please. And speaking of where we are overall in terms of the public health weight that we're enduring here, the triple-demic is still here, it's still real. We are living with a fair amount of flu as well as RSV and COVID-19, including the new and highly contagious, if not record-breaking in its contagiousness, subvariant XBB 1.5 that's really taking hold within the Northeast. increased. And unfortunately, hospitalizations and deaths specifically relating to COVID have been creeping up in these last weeks, as you can see on the slides here. And so we'll be tracking this all very closely as we move into 23. We're hopeful that there's better around the corner, and we'll be here to work with you to ensure you have the information as it relates to your businesses and all that you do, because this information, of course, really does matter. With that, though, I want to make sure that we give time to our speakers ahead of me in the program, the first of whom is Dave Ferrara. And Dave, we're thrilled to have you back. Dave, you were sitting with us in the Syracuse office, and Dave has, as I mentioned, been on the program before to cover labor and employment matters. And Dave is prepared to look back at what it looks like from the labor and employment vantage point in New York State. What did we learn in 2022? Dave, the floor is yours to walk us through. And again, really
great. Thank you, Dave.
Thank you.
And thank you, folks. After 35 years with the firm, it's very rewarding to see so many of you still being clients and actively part of the Bond family. So thank you. I want to apologize for my voice. I've been battling a little bit. I was going to take protected leave, and Bond assured me that they would not take any retaliatory action against me. But being the guy I am, I just wasn't, want to be sure. So I'm glad to be with you today. Let's first look at Section 740 of the labor law that just recently got amended. You'll recall the old law. It was a very high standard regarding notice, and the protection was not that broad. It was very, very limited. There was some non-retaliatory language, but the new law takes it much broader. An employee only has to make a good faith effort to inform the employer, and unless there's imminent danger of public health, or they think the employer may destroy the evidence, or if the employer is already aware of it and they will not correct it. Would you go to the next slide, Kathy? And that's where I think we're going to see a lot of activity. As you know, many times a plaintiff's lawsuit will start with, in the discrimination area, the company knew or should have known. And invariably, they're talking about some supervisor that unfortunately was told something who didn't bring it to HR's attention. So I urge you here, be sure that you're updating your supervisors and training to make sure they understand how important it is to communicate these types of notifications to them out on the floor. Next slide, please. The statute also only presents if the employee, reasonably believes, okay? And then if there's any violation of any law, rule, regulation, or even administrative decision. So the protected activities become much broader under this statute. They raised the statute limit, or extended the statute of limitations to 2 years instead of 1. And the real game changer, folks, there's now a right to a jury trial, which of course, anytime that is interjected, the stakes get significantly more expensive for employers. Next slide, please. Labor Law 215 amendment. As you can see, the governor signed it in November. It's focused on no-fault attendance policies. Now we got to look at our policies in terms of any demerits, occurrences, point system, no-fault system. All of these policies should be looked at very, very closely. And any complaint by an employee alleging any labor law violation could give basis to protected activity that in turn could give rise to a retaliation claim. So this is going to become, I think, heavily litigated as time goes along. There's a 2-year statute of limitations here. So I call your attention to that because, again, I do think you're going to be confronted with claims under 215. Next slide, please. 206C, I won't spend a lot of time here, but you'll recall, and we went over this, I think, last month or 2 months ago. Now it's the right, 206C protects any nursing employee, doesn't have to be the mother, okay? And must be provided a reasonable break time, permit the employee to express milk for each time such employee has the need, and for up to 3 years after the child's birth. Now, this is not coming until June 7th of this year. Next slide, please. But we would encourage you to start making preparation because, as you can see, you have to designate a room or a location. It has to be in close, reasonably proximity to the work area, well shielded, free from intrusion. Obviously can't be a restroom or a toilet stall. And at a minimum has what's listed here: chair, working surface, running water, electrical outlet, and refrigeration, if there's any refrigeration in the workplace. So the message here, next slide, please, is twofold. The Department of Labor has not issued the policy yet. And I would encourage you to start looking at revising or initiating your own policy, and make sure it's part of your onboarding process so that employees are notified upon hire, as is required by the statute, and annually thereafter. There are anti-retaliation provisions. So again, you might have a supervisor that's uninformed. They're thinking the employee's taking advantage of their break period or their meal period. You want to make sure your supervision is informed of a particular request to take advantage of this benefit. Next slide, please. Other amendments last year, back in March, there were 3 confidential hotline for sexual harassment complaints. I'm going to come back to that in a minute. Both now the state of New York and all public employers are subject to the human rights law, where some were excluded before, and it prohibits release of personnel files as a retaliatory action against employees. Finally, rest assured, more is coming, right? I mean, this governor is very, very public and very transparent that she believes more needs to be done in the way of protecting employee rights under the human rights law. And I think you're going to see additional staffing and resources provided to help beef up that particular department. Okay, next slide, please. With respect to the hotline, this was announced back in July. It's open daily. It's staffed by pro bono attorneys. There's a question regarding posting requirements. The division was supposed to be updating the model posting for employers to use. We've not seen it yet. Recommend looking at your policies in the sexual harassment arena. And in my mind, you might as well go forward, put the notice in there. I believe you're going to be required for sure. And let's just be done with it so that whenever we do see the model posting, you're ahead of that curve. Okay. Next slide, please. Section 203E of the labor law amended to prohibit employers from discriminating any retaliatory action based on an employee's reproductive health decision or using or accessing a particular medical service. Now, remember the Dobbs decision, Dobbs v. Jackson, overruling the long held anti-abortion statute or case. So I would suspect we're going to see claims where employees are either denied or granted assistance by the employer seeking certain reproductive health decisions. Depending on what those decisions are, you may see some claims under 203E. Again, there's a notice requirement that has to be posted for all employees, explaining what their remedies are. So it's another reason to refresh the handbook and make sure that we have given notice. Now, as you can see, there is a federal court decision that enjoined the notice provision. So at least for now, it's been enjoined. However, it doesn't invalidate 203E's prohibition or protections. So the notice may be in question, but there is nothing precluding the state from enforcing any violation of 203E. Next slide, please. Back in May, the civil rights law got amended, section 52C, requiring employers to engage in electronic monitoring to communicate and notify employees. Again, I think the concern here is making sure new hires get notice. And for those of you that I'm sure have a very extensive onboarding process, to me, that's the place to do it. This way, it's taken right from the beginning as part of your onboarding packet that the employee is notified. And then, you can have the additional follow-up either electronically as they open an email or, log into your system, but make sure you get the new employees when they're hired. Next slide, please. New York City's Wage Transparency Law, for those of you that work in the city or some of your employment opportunities are in the city. It became effective 2 months ago, November 1st, requires all employers to include minimum maximum salaries for any advertisement, job, promotion, or transfer. And there's got to be a good faith determination of what the salary level is going to be. I don't think there's any more hiding behind we're uncertain as to what the range is going to be. I think you got to establish some basis for a salary range, and you've got to communicate that salary range. And remember, you got to comply with this statute, even if only, one employee is currently working in New York, including remote workers that are working in the city. So unless you can establish that the covered position cannot be performed, even in part, within the city, you're going to be subject to that statute. Next slide, please. Same transparency law, but at the New York State level, enacted in 22, not going to be effective until later on in the year, in September. And again, minimum maximum salary range of compensation and a job description if one exists. Okay. There'll be more coming in our future webinars on this as we get more guidance as we get closer to the effective date. And lastly, I want to wrap up two points. Digital workplace postings. Folks, as you know, just last month, 201 was amended that now requires mandatory workplace postings available to applicants and employees electronically. Now, there's some question as to whether applicants are absolutely covered by this statute, and I won't bore you with the construction of the language. I think we will see more guidance coming out, but in the interim, our sense is don't restrict it to employees. I think you have to. I'd err on the side of caution here that you are also providing some. It'll be a subset of the postings that employees are required to see, but I would include applicants in your digital communications of federal and state notices that are otherwise required. And then finally, just running down the minimum wage salary thresholds. To me, the biggest issue here is for salaried exempt employees, making sure that we've got the threshold met. So for minimum wage in New York, up $1 to $14.20, that's upstate. New York State plans to increase across the state to 15. We're not there yet. New York City is there, okay, 15, there was no change. And then again, is the salary threshold I mentioned at the outset for exempt under both the executive and administrative exemption. This does not involve the professional exemption, has increased to $1,064.25. So let's make sure those numbers are in place and whether or not you can continue to meet the exempt classification or the exception under the exempt classification. In New York City, it's 11.25. In 23, eligible workers now under the family leave can take up to, can take up to 12 weeks of leave. And you can see the numbers here. They've removed the 60-day cap on intermittent leave effective 1/1/22. And they expanded the definition of family member to include siblings effective 1/1/23. So again, I think there's the takeaway from all of this is there are a lot of reasons to be looking at your policies, looking at your handbooks. I know it's difficult to keep them updated, but this year seems to be more important than most, at least in my recent experience, to make sure that we are updating the policies to comply with the various amendments. Gabe, I think that does it.
Well, Dave, thank you so much for taking the time to walk our audience through all that has been so important in the employment and labor world during 2022. And Dave, as you signaled, there's much that we need to be mindful of as we move here into 23. And why don't we shift gears, and we'll now bring John Godso to the program, or back to the program, as it were. John's with us from Buffalo, and we'll be looking in particular at the employee benefits world as it relates to all of you. There's a lot that took place during 2022, and John's here to make sure that you're up to date. John, the floor is yours, and thank you for being with us.
Thanks, Gabe. Good afternoon, everyone. If we could just go to the next slide, please. So I want to just start off with the big picture look here, kind of the 30,000-foot view of the developments over the course of 2022. And starting with Supreme Court decisions, Dave actually mentioned one of them, the Dobbs case regarding the federal abortion right. That also impacted employee benefit plans and employer travel policies, for example, for those employers who were trying to make it feasible for employees in states where abortion was restricted to other states. So that had an impact on employers and employee benefit plans, as well as Hughes v. Northwestern University. And we'll talk a little bit more about each of these cases in the upcoming slides, which really impacted retirement plan administration and plan governance issues related to 401k, 403b plans and fees, et cetera. So it's not often that we get Supreme Court cases in the employee benefits world, but this year we had a couple impactful cases for plan administrators and plan sponsors. On the legislation side, a little bit of the health and welfare side, as well as the retirement side. First, on the health and welfare side, there were many provisions in the Consolidated Appropriations Act of 2021, which was passed right at the end of 2021, but many of the provisions were implemented in 2022. Those required us mostly to work with our either third-party administrators if we were self-funded, or insurance companies, to make sure that we were compliant with the various disclosure requirements and transparency requirements that were in those acts. Secure Act 2.0 just got passed actually at the end of 2022, and we'll talk a little bit more about that in upcoming seminars and presentations, but that came right at the end of 2022, talked a lot about in 2022 regarding improvements to the retirement plan system through the Secure Act. Enforcement, I think we've seen a little bit of the COVID-19 impact as far as our experience on the DOL and IRS side from enforcing their mandates with respect to employee benefit plans. I think because of work at home policies for the IRS, for example, and the DOL, we haven't seen as much of a enforcement priority over 2022. We expect that likely to change in the upcoming future. The Inflation Reduction Act, for example, which was passed in 2022, provided for about $46 billion in additional funding for the IRS. We're not sure exactly how that may be used on the enforcement side. It may be used to increase audit activity, although with the new Congress coming into play in 2023, that may shift as far as reducing the influence of the IRS. But we do see the likelihood, based on actions in 2022, for a little bit more enforcement activity coming into the 2023 year. And costs, I think a big picture that all of us try to equate when we're talking about our employee benefit plans is, how is policy and new regulations and requirements going to impact us from a cost perspective? We certainly saw benefits costs influencing personnel decisions and plan design considerations in 2022. Because of the increased healthcare costs, we saw a lot of employers moving from an insured plan, for example, to a self-funded medical plan. We saw companies thinking about implementing early retirement programs, which contain a number of fairly particular requirements in order to satisfy the legal requirements associated with such plans. We also had a lot of employers looking at modifying their retirement plan structure, the benefits provided under those retirement plans. So a lot of consideration as costs became moved to the forefront, I think, for employers moving a little bit outside of the COVID period. Kathy, if we can go to the next slide, please. So speaking of COVID, I like Gabe's slide earlier about not yet out of the woods. I did want to make a mention of the impact of COVID on plans in 2022, because it is spilling into 2023, although there's an expected decision in the early 2023 regarding this particular issue here and the impact of the national emergency. If folks recall, a national emergency was declared in 2020. That is still ongoing. President is going to decide on whether to continue that in February of 2023. But the impact of benefit plans in 2022 was basically the required time periods for certain elections and certain notices and certain decisions got tolled during this national emergency period. And basically, the tolling period was either the lesser of 1 year or 60 days beyond the date that the national emergency period is declared to be over. So, for example, with our our COBRA elections, with respect to time periods in which folks can make appeals under a plan, all these time periods were told in 2022, which required a bit of a difficult administration from plan administrators and those in the HR world, figuring out exactly when these deadlines ended, exactly when COBRA premiums, for example, needed to be paid, exactly when notices needed to be issued. Now, we expect, again, a decision in February 2023. Hopefully, at that point, the national emergency may be declared over, at least with respect to this issue and the ongoing requirement to toll these benefit deadlines, but something for administrators to continue to think about and continue to look out for when that national emergency period might end in 2023. Next slide, please. So health and welfare plans, just big picture. We talked a little bit about the Dobbs decision overturning Roe v. Wade, declaring no federal right to abortion under the U.S. Constitution. Many employers considered some alternatives or some form of abortion-related services in states where abortion is restricted or prohibited. That really came in the form of some type of travel reimbursement program. There's a lot of different legal considerations that go into that travel reimbursement program, making it comply with federal law. We think we may see some more activity in the space going into 2023, but certainly something employers may be fielding questions from your employees, maybe getting some pressure, perhaps, depending on the circumstances regarding these types of policies. So something we expect to see a little bit more of in 2023 as well. Affordable Care Act, always a big issue, especially for those large employers who are supposed to be providing affordable coverage to their full-time employees. What we saw in 2022 is continued enforcement with regard to the employer shared responsibility requirements. A lot of notices from the IRS on the side of filing requirements, 1095-C, 1094-C, making sure those are accurate. If you've ever been unfortunate enough to receive a notice from the IRS in this regard, the numbers can be staggering initially because there are fines based on your number of full-time employees. So we want to make sure that employers are making sure that they're filling out those 1095-Cs and 1094-Cs correctly and making sure that we can avoid any issues with respect to the IRS and complying with those Affordable Care Act requirements. Implementation of the CAA. This was really a lot about transparency and disclosure. New price comparison tools are required, machine readable files, broker and consultant compensation disclosure requirements. These really are the requirements I spoke about earlier, where it's imperative to be dealing with your third-party administrator and insurance company to make sure that we're giving the proper disclosures and that we're complying with these new CAA provisions that came into effect in 2022. Next slide, please. So retirement plans, Hughes v. Northwestern University was the other Supreme Court case that I referenced earlier. This was really a case in a long line of cases dealing with high fees associated with either with a 401k plan or a 403b plan. And it was really a reminder of the importance of a prudent process, both in selecting investments with respect to your retirement plans and analyzing fees. In the case of the Northwestern University case, they had a wide lineup of many funds that many people would consider prudent from a perspective of fees and performance, but it had a few that were not performing well. And the court basically said, hey, you got to look at every single particular investment in your lineup. It's not good enough just to say most of your fund lineup is low cost and performing well, you have to look at the lineup as a whole. So this was a reminder really for us to have a prudent process in place when we're doing our 401k, 403b plan governance. Updated RMD rules. This really are those required minimum distribution rules that dictate when distributions need to be made from plans based on participants reaching a certain age. Very technical requirements. We really have to be working with our TPAs to make sure that those distributions are being made in a timely manner. We got new rules from the IRS on those in 2022. Cryptocurrency, kind of sign of the times. A lot of plan sponsors looking to perhaps add a cryptocurrency element to their 401k plan or 403b plan. The DOL issued guidance early in the year, basically cautioning sponsors to exercise extreme care in the case of cryptocurrency and adding such investments to the retirement plans, basically because of the speculative nature, among other things related to cryptocurrency. So we've been advising plan sponsors, plan administrators to consider that issue carefully if you're thinking about adding cryptocurrency based on that DOL guidance it received in 2022. And then the Secure Act, finally, Secure Act 2.0, recently passed just at the end of 2022. The implementation phase will start in 2023. This is a little bit of a teaser. We will provide some more information on the Secure Act in future webinars, but it really builds on the Secure Act, what I'll call 1.0, which was passed in 2019, encourages retirement savings. It's really broad scope, a lot of provisions in it, automatic enrollment provisions in it, provisions regarding additional catch-up contribution opportunities. So something to look out for in 2023 because it'll be impacting your retirement plan, and look out for future webinars and information from us. So Gabe, that's all I have for the moment. That's the quick wrap up of 2022.
And quick yet thorough it was. Thank you so much, John. We look forward to having you back on future programs, and there's much that we'll be learning together as we move into 23 when it comes to the benefits world. Shifting to a different world where Bond has attorneys focused on your behalf, it's higher ed, and Seth Gilbertson is back with us. Seth has spoken on a number of different issues over the course of 2022 and is here to provide the high notes on what was significant in the higher ed world during the last year. And Seth, looking forward to learning along with you. Thank you so much for taking the time.
Thanks for having me. Back again. I told Gabe before this, and I'll tell you all now, I know this is the looking back section of the program. But many of the issues that we're facing sort of straddle the year here. And indeed, this is actually sort of the middle of the year for higher education. It's the new year for most people, but we work on academic years, and this is right in the middle of the 2022-2023 academic year. So many of these issues tend to sort of merge both worlds together. So it's going to be a bit, we're going to looking at what happened, but also what we think the implications that are going to be, or what's going to happen next. What's the next domino to fall in some of these areas. I also mentioned that I'm going to be back next week talking about some additional issues. We had too many to fit into one window here, so they were kind enough to give me 2 segments to work these out. So we're going to hit a few of them today, and then I'll be back next week to hit a few more. Next slide, please. The first one I want to talk about is race and college admissions. Obviously, kind of a hot button issue that gets a lot of press, a lot of people pay attention to beyond those who are immediately affected. The Supreme Court last focused on this issue not too long ago, just in 2006, in a case called Fisher versus University of Texas. That was a 4-3 decision, a bit of an odd number for a Supreme Court decision, but there were only 8 judges on the court, and Justice Kagan at the time had worked on the issue during the Obama administration, so she recused herself. Which left 4 judges in the majority. Only one of those, only Justice Sotomayor, is now currently on the court. So although it's been a very short period of time, there's really been a drastic change in the makeup of the court, at least as it pertains to this particular issue. And I think that's going to lead to a drastically different outcome, frankly. There are 2 cases, one against Harvard, one against the University of North Carolina. not by chance that that happens to be against a public and a private institution, both large institutions with a lot of notoriety. The entity that is in the plaintiff here is Students for Fair Admissions, which is also the group that was behind the Fisher versus University of Texas decision. It's sort of a conservative activist group. I think I could fairly characterize Students for Fair Admissions as, and this is their main issue. So they've successfully brought another couple of cases to the Supreme Court. Those cases this is truly straddling both sides of the year here, in that the cases were argued in October, but we don't have a decision yet. So we are waiting. Now the cases have basically been fully submitted essentially to the court now. We're just waiting for a decision. I rarely predict decisions, but this one I'm going to go out on a limb. You would need 2 of the 3 Trump appointees on the court to vote to uphold affirmative action policies in order for those policies to survive. At least that's how I count the numbers on the court right now. I see that as very unlikely. The real question, I think, comes down to, will the ability of colleges and universities to consider race in admissions be curtailed or essentially eliminated? So I think it is more a matter of how far the court goes rather than what the sort of direction it's going to go in is going to be. I think for those of you who are not in higher education, there could be some downstream effects in ability to consider things like race and ethnicity in hiring decisions, as trying to promote a diverse workforce. Those may become curtailed because many of the same principles that apply to race and admissions apply to other areas. Corporate boards is another area where there's been a sort of push to diversify how those boards are constructed over the last few years. That may be rolled back a little bit by this kind of determination as well. Next slide, please. Another issue straddling here, the Department of Education released new Title IX proposed new Title IX regulations last year. They're likely to go into effect this year. So we know what the regulations essentially are. We don't have final form, but we have the proposed regulations. The administration has been working on these for a long time. I don't think there's going to be a lot of changes. Many of you have heard me talk about this issue before. I just listed a few of the significant impacts here. There are many. A much broader definition of what constitutes actionable sexual harassment, a much broader definition of what constitutes a formal report that a college or university needs to act upon, or a primary school for that matter, may need to act upon. Those reports a report could be made to a faculty member now, for instance, whereas that would not have been a formal report under the current regulations. Codifies protections for sexual orientation and gender identity, although those have already essentially been put in place by the courts now under Title IX, but we're going to actually have those codified into the regulation. And then revamp grievance procedures. The current procedures are fairly strict, fairly regimented in terms of what procedures an institution needs to apply to a Title IX grievance. There is more flexibility in the proposed regulations. There is also going to be more obligations. So sort of giveth and taketh away. At the same time, we are going to have some more flexibility in how we craft our policies, but those policies still have to meet a lot of benchmarks along the way. I think ultimately we need to be prepared to implement these regulations going into the fall. We don't have an official date yet, but I think to be on the safe side, going into the fall semester of 2023, most institutions should be prepared to comply with the new regulations. Next slide, please. Remote hybrid models. This is nothing new to any of you, even outside of education. This is just becoming part of the world that we live in now. Many people are doing things remotely that they used to always do in person. That's no different in higher education. This will have cascading effects, I would say, on the campus environment on many institutions, as there are fewer students around. Parking may be easier to find, but just many students now have, I think it's probably rare to find students that have all their classes. Maybe a first-year student, freshmen, sophomores, still have a lot of their classes in person, but many more students, even at traditional institutions, now have at least some of their courses in a hybrid format or fully remote format. That's going to change the nature of some academic programs. Many institutions are going to have to look to as they're enrolling students from foreign jurisdictions or other states jurisdictions that have different licensure and accreditation requirements. Those institutions are going to have to comply with those distant accreditation and licensure requirements. Employees, same effects as we see everywhere else across the labor landscape. Multi-jurisdiction employment institutions need to be ready to comply with the jurisdictional rules of the location where the employee is actually performing the work in many cases, which may be far away from where the campus location is, which is the model that has always been traditionally used. Many campuses are instituting remote and hybrid work policies. If they haven't already, they're all working on them. And remote and hybrid work is one of the more common requested accommodations that we see nowadays, and we need to evaluate those, which can be particularly tricky in the case of faculty, I will say. Whether the modality of a course that would be taught in person can be changed to be remote in order to, as a reasonable accommodation for an individual faculty member is an issue that we're dealing with quite often these days. And I certainly encourage you to reach out to your counsel that you work with if you have one of those types of accommodation to requests. Next slide, please. Finally, for me today, and I'll move off, is changes in the student loan landscape. We know last year the Biden administration announced a loan forgiveness program that has since been held up in the courts and moved up to the Supreme Court on sort of a fast track. So we're going to get some ideally, I think, some resolution on that. In the meantime, there's been a pause on payments that's been affected for most student loan borrowers have not made a payment since the beginning of the COVID pandemic. That is still that pause is still largely in effect, sort of pending the outcome of this litigation. There's currently an injunction in effect, so the borrower forgiveness has not gone into effect. And today, or I think it was yesterday, actually, the Biden administration announced a revamp of a repayment program that essentially is meant to consider income and base payments on income. All of these things are going to have major effects, I think, and may contribute to us reaching an inflection point in higher education where cost controls are going to be required by regulation and or market forces, as we also see continuing declines in enrollment. Sorry to move so fast, but I'm always happy to discuss any of these issues with anybody who wants to. Please feel free to reach out to me. With that, I will hand it off, though. And I'm going to skip that next slide, and we'll do it next week. Oh, you're on mute.
Yes, I am. Thank you. I thought I'd come off, and I do appreciate all that you've walked through quickly about 2022. There'll be more to come next week. And our final speaker of this afternoon is Rick Weber, who is back to discuss the Adult Survivors Act. Rick has been on the program a couple times previously to make sure that all of you are aware of its myriad implications. And because of its importance, we thought it was useful to bring Rick back on. Rick, thank you for taking the time. We look forward to hearing your updates as we look back on the implications of this act in 2022 and as we peer ahead into 23.
Sure. I hope you can all hear me. Welcome to the new year. The Adult Survivors Act, as you may recall, was enacted to essentially provide the same types of rights to individuals who had experienced sexual assault or sexual abuse who were adults at the time of the incident. And that's the same type of exercise as what legislature went through when it enacted the Child Victims Act. So next slide. Quick overview. The effective date happened to be Thanksgiving, November 24th of 2022. That was not in the act itself. It was a function of the act going live with an effective date 6 months after the date of its enactment. The law is in effect for 1 year. It opens a 1-year revival window for claims of sexual abuse that would otherwise be barred by the applicable statute of limitations. In other words, by the passage of time. One difference between this act and the Child Victims Act is that this is not limited really to youth-facing organizations. The majority of those lawsuits that we saw under the Child Victims Act were suing schools or churches or community organizations that addressed specifically children as a service population. This act has no such natural limitation. If a victim was allegedly assaulted or a victim of sexual abuse from age 18 on, this essentially gives them the opportunity to file a lawsuit about that, regardless of the context that it occurred in. It's also important to know this is not a criminal statute. While it borrows some language from criminal statutes to define the types of acts that are subject to this revival statute, it is not a criminal action in and of itself. The end goal of this statute is to provide some monetary compensation to the victims who can prove their case. Next slide. Let's see. Okay. Important to know that the new law is not limited to intentional acts of the individual abuser. Most of these lawsuits are asserting that there was an entity, a business, an institution of some kind that was responsible for the acts of the abuser and that should have known or did know that the abuser was engaging in such acts. So the types of claims that you see are claims of negligent supervision, negligent hiring, negligent retention, right? Once there were some problems that may have come to light, the individual was allowed to remain as an employee or a volunteer with the organization. And also negligent training. These individuals weren't properly trained in how to act in the workplace. All these types of things. Again, the law allows recovery for physical, psychological, or other injury or condition resulting from conduct which would constitute a sexual offense or incest. I will tell you that obviously implies compensation for physical injuries, psychological or mental health conditions, but other injury could relate to things like lost income for some reason, lost particular opportunities. The plaintiff would have to prove that, but it is revived just as they're revived for physical injuries or mental health injuries. Again, as I mentioned, the new law incorporates the criminal law terms to define certain things, definition of what rape is, criminal sexual act, forcible touching. Next slide, please. I focus real quick on forcible touching because that's a term that really does have a specific defined connotation within the criminal law. And this act borrows that definition to address things in relation to this civil law, this revival law. So really, it's pretty broad. Things such as, non-consensual touching, grabbing, pinching, rubbing, squeezing, groping, all of these things that you might imagine could happen now become actionable. In addition, claims of facilitating a sex offense with a controlled substance. That's your date rape claims, where somebody has allegedly drugged the victim and took advantage of the victim while they were drugged. Those are also revived. Next slide, please. A couple other quick points. There's no limit on the age of claims. These could be however old the victim is at the time the victim sues the case. Some key points: if you're a potential defendant, if you're aware of the claim or you have a concern that a claim may arise based on something you know institutionally within your organization, you should probably start the process of trying to identify and locate old insurance policies, because obviously insurance coverage is important. And as we saw with the Child Victims Act, it's often very difficult to piece together who might have been providing coverage to your organization in the 1950s, 1960s, 1970s. Here, we find often that there are potential defenses that can be raised. These include lack of notice. In other words, that untoward conduct may have occurred, but nobody reported it. The organization was not in a position to be able to take action to address it. It remained, for better or for worse, unknown to the organization. That's a lack of notice issue. Also, unlike the Child Victims Act cases, there may be questions of consensual conduct in these types of cases. If there is an issue where a young employee asserted that she was subjected to inappropriate sexual advances and abusive conduct by a supervisor, causing her to leave the company, there may be a question of whether that employee, in my hypothetical, consented to the conduct, the actual contact. Was this a situation where there was a consensual encounter and then it evolved over time into something else and became unwelcome conduct? One caveat to that is that we have a very good knowledge now about how certain individuals groomed, quote unquote, the individuals they targeted for abuse. And so the issue of consent may not really be something that is a full defense if, in fact, it turns out the consent was not a genuine consent situation, that there was some kind of inappropriate force or compulsion applied to the victim, that they really didn't have an ability to consent to the activity with free will. That's an overview of the Adult Survivors Act. The Adult Survivors Act has been live now for about 6 weeks to 2 months. And the question is, what kind of things have we seen arise so far? Next slide. So the first category of claims we've seen are new claims against individuals. There were claims under the Adult Survivors Act brought against Donald Trump, Bill Cosby, Ed Henry, a former Fox News host. These are all fairly high-profile claims. There's been press coverage of all of these. Oftentimes, especially in the case of Fox, there's some question of whether the employer is also being covered by the lawsuit, whether that employer is allegedly responsible for the conduct. There are other claims. For those of us who watch this area, the Robert Haddon case is prominent. Robert Haddon was a prominent physician, had posts at Columbia University and New York Presbyterian. There was a series of Adult Survivors Act claims that he was acting inappropriately in the conduct of the performance of his medical duties or in the context of medical appointments. Also, there's a lawsuit against the New York State Attorney General's office on the theory that a former chief of staff at the AG's office engaged in inappropriate conduct related to certain other staffers. That chief of staff was let go from the office, but there's some questions on whether the office has some liability in relation to his activities as well. One thing that struck me as interesting, as I'm sure most of you know, Jeffrey Epstein was an individual who famously engaged in abusive conduct of young women. There are now lawsuits that are being alleged against his estate. And so the administrators of his estate are confronted with having to work through the history of that, where they don't even have the individual who allegedly committed the abuse to be able to interact with, to investigate and figure out the potential merit of the claim. Finally, the next large high-profile category of cases would be the lawsuits against state agencies. Most notably, the New York State prison system. Bedford Hills is a good example, but not surprisingly, a large number of inmates in the prison system have asserted that prison guards, prison aides would inappropriately assault or abuse them during the course of their internment in these prisons. And there are a large number of these lawsuits indicating that the Bureau of Prisons is responsible and should have taken action to protect them against such assaults. This could also include not only staff, but other inmates who engaged in such assault, who were under the supervision and custody of the Bureau of Prisons at the time this occurred. These are some of the high-profile types of actions we're seeing, parties that we're seeing. It is certainly reasonable to expect that as the year goes on, we will see lawsuits against a diverse array of private entities and private companies. Think health clubs, for example, where there may have been inappropriate contact or some type of regular inappropriate physical contact with another. Think about conceivably bars or taverns where there was an individual who was known to the bar or the tavern to engage in inappropriate groping or contact with women. These are possible claims. Claims against universities, for example. In each of these claims, what will be important is trying to piece together the exact events that may have occurred 30, 40, or even 50 years ago. So we'll plan to give further updates as this evolves. But that's kind of a high level view of where we are on the Adult Survivors Act today. Thanks.
Rick, terrific. I thank you for taking the time to bring us all up to speed. Speaking of time, we're a bit over our allotted time today, but we thank you for sticking with us. There was, of course, a lot of informative programming from Dave, John, Seth, and Rick. Thank all of them for being with us. Next week will be part 2 of our look back into 2022. And then as we move later into the month, we'll have 2 programs devoted to peering ahead into 2023. So stay tuned. We're grateful that you are with us. Our audience is one that we really are grateful for. We thank you for taking the time to learn with us every Tuesday, and wishing you a terrific start in 2023. See you soon.